Self-defense, what does it mean? The law has long recognized that if you're in a fight, you're entitled to use reasonable force in self-defense. But how far does that concept stretch? What's meant by reasonable force? In this video, I'll discuss what the law actually says about how far the concept goes, about when you can rely on self-defense if you've been arrested by the police, and how far the concept of reasonable force actually goes. Let's start with when force is lawful. You'll have heard about many different types of criminal offence where force is used. They're most commonly known as ABH or GBH, actual bodily harm, grievous bodily harm. They're really the same thing, but what differs is the amount of injury that the victim of the assault sustains. Sometimes it's known as battery. That doesn't mean you've battered someone in the traditional sense of the word. It just means you've made physical contact with somebody. Self-defense is when the law allows the use of physical force so that your use of physical force isn't unlawful, isn't a criminal offence. Under Section 76 of the Criminal Justice and Immigration Act 2008, a person may use such force as is reasonable in the circumstances as the person believes them to be, for the purposes of self-defense and defense of another, defense of property, prevention of crime, and lawful arrest. Now, these defences are all linked. They work mostly in the same way, but we're going to focus on the first one, on self-defense. A person acting in self-defense is allowed to use such force as is reasonable in the circumstances as he or she believes them to be. Now, let's just break that down. Let's focus first on what's meant by the circumstances as he believes them to be. This looks at what the person genuinely thought and believed before they used the physical force. Did they believe they were in a situation where physical force was needed? It doesn't matter whether they were mistaken in their belief or not, it's purely what they think. So for example, a fairly far-fetched example, imagine somebody thinks that they're about to be attacked by a warrior with a samurai sword. In fact, it turns out to be a little old lady wielding an old-fashioned umbrella. The fact they might have thought genuinely that the attacker was somebody wielding a samurai sword and they were mistaken is actually irrelevant, because the law looks at what they believed the circumstances to be and then allows them to use reasonable force in those circumstances. Now, the little old lady might have a civil claim for damages if excessive force was used, but if the person genuinely believed the circumstances to be that they were being attacked by a knife-wielding warrior with a samurai sword, they're not going to be liable if they use the appropriate level of reasonable force in those circumstances, because they believed at the time they were using reasonable force. However, if you were mistaken about the situation because of voluntary intoxication, so if you've got yourself drunk or if you've taken drugs and that's affected how you perceive things, then you can't rely on your belief, your genuine belief, as a defence. And that's Section 76, subsection 5 of the Criminal Justice and Immigration Act 2008. Back to the definition in Section 76. A person may use such force as is reasonable in the circumstances. What does that mean? How much is reasonable force, and what would then be excessive force? Unlike the first part, where the circumstances are what you genuinely believe, whether reasonable or not, the question of reasonable force is decided objectively. Would the reasonable person think the force you used was reasonable? And that is decided by the jury or by the magistrate, whoever's deciding the case. Do they think that the force you used is objectively reasonable in the circumstances? Disproportionate force is obviously never going to be reasonable. So, for example, if somebody pushes you and you react by taking out a knife and stabbing them, that's going to be disproportionate, and it's not going to amount to reasonable force in self-defense. The level of force that's considered to be reasonable or not depends, however, on the situation as you genuinely believe it to be, if unimpaired by drink or drugs. So if you believe that little old lady wielding the umbrella was actually a warrior with a samurai sword, it can be reasonable to use reasonable force that you'd expect to use when faced with somebody wielding a samurai sword rather than an umbrella. Reasonable force is a wide concept, The law doesn't expect you to behave perfectly, and it recognises that sometimes you need to take a split-second decision. So the question is, was the force you used reasonable in the circumstances at the time? If the circumstances needed a split-second decision, then that's taken into account in deciding whether your force was reasonable or excessive. Are preemptive strikes allowed? Yes, there's a famous criminal case called The Crown against Hussey, where the judge said, in defending his home, he need not retreat, as in other cases of self-defence, for that would be giving up his house to his adversary. What does that mean? Well, it means you don't need to wait till you've been punched. You're allowed to throw a preemptive punch if, in the circumstances as you believe them to be, a preemptive punch would be reasonable force in those circumstances. Who has to prove it? The magistrates or the jury have to be persuaded of your guilt beyond reasonable doubt. Sometimes that's called they have to be sure of your guilt. And it also means that it's not for you to prove that the force you used was reasonable. It's for the prosecution to prove that it wasn't. The prosecution have to prove that the amount of force you used was unreasonable, was excessive, so that the jury or the magistrates are sure that the force you used was disproportionate in the circumstances. Self-defence is available in a very wide range of cases as a defence. It's available in every single sort of case involving physical violence except sexual offences. And the reason I say except sexual offences is because you couldn't really say, and I'm taking an exaggerated example again here, you couldn't really say, well, they were about to attack me, so it was reasonable force to rape them. You can tell how that would not be a sensible or a valid defence. I hope you enjoyed watching this video. If you found it helpful, please do subscribe and click the notification bell so you hear about new explainer videos as and when I record them. I upload about 3 a week, explaining all different aspects of English law. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye-bye.